Engineering Limited and another, and the Commissioners for HMRC.
Mr. Thornhill.
My lord, I appear in this matter with my learned friend Mr. Welsh, and my learned friend Rebecca Murray appears for the Crown. And what is before the court are two issues concerning deductibility, or what are commonly referred to as unfunded pension arrangements. That is to say, in this particular case, arrangements where the trading company has simply made a promise to pay a pension, but not set aside any funds in any way to meet the pension liability. And the two issues are, first of all, sections, I should say, 1290 following of the Corporation Tax Act 2009. And the second issue is a more general deductibility issue. We could perhaps refer to it as a wholly and exclusively issue. The first issue is of comparatively recent origin, but of course the wholly and exclusively issue goes back into the mist of time, back into the Income Tax Act of 1842. In the closure notices, I don't think I need take the court to them. The way it's put is, first of all, sections 1290 following, but if they don't apply, not wholly and exclusively. Both sections 1290 and the wholly and exclusively rules make inroads on the general principle, which I don't think I need refer the court to. It's in section 46 of the Corporation Tax Act 2009. It's in the authorities. Section 46 says, or lays down, that the computation of profits should follow general accounting principles of general accounting practice, but subject to any specific inroads that are made by legislation. And obviously section 1290 is one such inroad, and the wholly and exclusively rule is another. What I propose to do, if the court is happy, is to divide what I have to say, like Caesar's Gaul, into three parts. Part one is to take the court to the legislation and to show the court that there is a very clear and simple divide between, on the one hand, contributory schemes, and on the other hand, non-contributory schemes, and also to demonstrate that in certain circumstances, unfunded pensions are given very valuable deduction rights. They're part of the tax system, and that the court will appreciate may be important if one is seeking to find the natural result of expenditure. If one finds that the legislation encourages that expenditure, then it becomes part of the natural and expected result. It isn't something, for example, which is artificial. And that is a very important point in my respectful submission in these appeals. That's part one. Part two asks the question, what is the right test flowing from cases such as Scots Atlantic, Hoey, and Marlborough, pausing there, all cases concerned with schemes conferring tax advantages? What is the right test to determine deductibility in the light of the fact that schemes in question were aiming at tax advantages? My lord, the importance of asking that question is simply this. If the court asks the wrong question, if the tribunal asks the wrong question, by misunderstanding what the cases decide, then inevitably that wrong appreciation is going to influence the result. And we say that is, in this particular case, in these two cases, a clear error of law. It's not an Edwards and Bairstow type case. That seems to have been what the upper tier thought it was, but it's not. We say it's important to understand the principle of governing deductibility where tax advantages are being sought. Only if you get the understanding right do you ask the right question. And if you don't ask the right question, you're going to get the wrong answer. And that is what happened in these appeals. The third part is very short. Ground 2 of the grounds on which permission to come to this court has been given are simply that if Scots Atlantic is authority for the very broad proposition that you cannot deduct expenditure where there is a tax purpose, then it wrongly decided and should be overruled. But our main contention is not that Scots Atlantic was wrongly decided, but that the upper and lower first-tier tribunals misunderstood the principles of that decision, extracted the wrong test, and inevitably arrived at the wrong answer. So going back to part 1, an essential starting point in my submission are two sections in the Finance Act 2004, 245 and 246, because these are sections on opposite sides of the same coin. One, 245, is dealing with contributory schemes, and the other, section 246, non-contributory schemes. If I could take the court to the authorities bundle at page 56, there we find section 245. Now, it may be said it's not very helpful because what we've got here is a section amending Schedule 24 to the Finance Act 2003. I'll go back to Schedule 24 in a second, but the court will notice the headnote, restriction of deductions for contributions by employer. And if we turn just for the moment to page 59, to section 246, that's headed restriction of deduction for non-contributory provisions. So that's why I can say to the court, well, these sections are two sides of the same coin, one dealing with contributory schemes, the other non-contributory schemes. To see what 245 is amending, could I ask the court to go back to Authorities Bundle page 4, which is Schedule 24. Now the importance...
Sorry, what page will we go to?
I'm so sorry,
Page 4.
4.
Yeah.
It's the very first
Yes.
piece of authority. This may look like a rather pointless historical trail, but the point I would make to the court is that Schedule 24 is the ancestor of sections 1290 following. So in order to understand what's going on, it's useful to go back to the starting point. And the court will see that in paragraph 1.1, the schedule applies where profits are being calculated, and B, a deduction would, but for this schedule, be allowed for that period in respect of employee benefit contributions made or to be made by that person. Subparagraph 2 defines employee benefit contribution, and it occurs if there's a payment of money or transfer of an asset to a third party, and the third party is entitled or required under the terms of the employee benefit scheme to hold or use the money or asset for or in connection with the provision of benefits to employees of the employer. Now, in the definitions, if we go to page 7, paragraph 9, interpretation, that your lordship see that the second definition is of employee benefit contribution, and that's simply to be read from paragraph 1.2, which I've just referred to. And then there's a definition of employee benefit scheme, and employee benefit scheme means a trust scheme or other arrangement for the benefit of persons who are or include employees of the employer. Slightly expanded, that definition recurs in section 1291 and forms an important item of dispute between the parties, because my learned friend will say that property is held under an employee benefit scheme, whereas we say, no, it's not. There's no contribution. There's no property held by a trustee or anything similar. But the importance in relation to that dispute, the importance of looking at the two sections, 245 and 246 together, is that it's very clear that Parliament was distinguishing contributory and non-contributory schemes. And the word contribution is an ordinary English word. And so when in Schedule 23, it talks about an employee contribution being made if there's a payment of money or transfer of an asset, one can see that that's a perfectly ordinary, straightforward use of the word contribution. Whereas, by contrast, if, as in the present case, the companies merely say, we promise at a certain future date that we will provide you with a pension, there isn't a contribution in any ordinary sense of the word at all.
Mr. Thornhill, one of the things that puzzles me a bit is we're looking, you've taken us to provisions of the Finance Act 2004. They've all been replaced under the tax law rewrite project. And there's
not
quite
all.
well,
245 has certainly been pushed forward to 1290.
Well, is 246 still in force?
Yeah, it's still there.
Neither party are relying on it.
Not expressly. I mean, I think what I'm pointing out, perhaps more clearly than has been pointed out below, is that you can see, if you go back to the starting point of this legislation, that there is a clear distinction between contributory and non-contributory schemes. But there's a more important point which I'm coming to in a minute, because section 246 is still in force. And when
Okay,
we
but
come to
245 is definitely not.
well, no, because it's been replaced by
Yeah.
sections 1295. But it might be helpful, my lady, to go to section 1290 now, because you can see the same terms coming up, but you with slight extensions here and there, but no major difference. If we go to page 83 of the authority fund. And there we have section 1290. And you see subsection 1, the section applies if in calculating for corporation tax purposes the profits of a company, a deduction will otherwise be allowed in respect of employee benefit contributions. Now compare that with Schedule 24, paragraph 1. The language is substantially the same. And the definition of employee benefit contribution and the definition of employee benefit scheme are repeated. I can say that if the court was happy to turn on to page 86, section 1291. First of all, subsection 1 tells you when there's an employee benefit contribution. And again, it's not exactly the same, but the general idea is the same. Property is held under an employee benefit scheme, and then B is an addition. And then what's an employee benefit scheme? That's shown by subsection 2, a trust scheme or other arrangement for the benefit of persons. Now, the persons in question have been slightly extended, but the definition of employee benefit scheme as a trust scheme or other arrangement is exactly the same as we had in Schedule 24. As you remember, in paragraph 9 of the definition sections, employee benefit scheme means a trust scheme or other arrangement, etc. So it's substantially the same legislation, but rewritten. But if you go back to the origin, you can see very clearly the distinction between property going into a scheme and property not going into a scheme because there's simply a promise. And the effect of Schedule 24 and the effect of sections 1290 following is the same. No deduction until taxable benefits are provided by the scheme. I don't think there's any dispute about this, but there was a major change in the taxation of earnings in 1989 to a receipts basis. And so the idea of Schedule 24 and Section 1290 is to postpone the deduction for the employer until taxable income comes out of the scheme for the employee.
Have I understood your point, therefore, that your Finance Act 2004 drew a clear distinction between...
I'm awfully sorry, my hearing is not brilliant, and I'm going to make a very stupid answer if I don't hear.
I'll start again. Do I understand your point, therefore, to be this, that the Finance Act 2004 drew a clear distinction between contributory and non-contributory schemes? The legislation in respect of contributory schemes is now reflected in Corporation Tax Act 2009,
Yes.
but the provision to which you draw our attention in relation to non-contributory schemes, namely Section 246 of the Finance Act 2004, is still in force.
Yes.
Is that correct?
That is correct, my lady, and I'm now going to explain why Section 246 confers advantages on certain, not all, certain unfunded schemes. To do that, could I take the court back to Section 246, which will be at page 59. And Section 246 starts off in similar vein, in some ways, to Section 245 in Schedule 24. This section applies in relation to employers' expenses for providing benefits to or in respect of present or former employees under an employer-financed retirement benefit scheme in a case where the expenses do not consist of making contributions under the scheme, but in accordance with generally accepted accounting practice, they are shown in the employer's accounts. Now, it's clear, therefore, from 2461A, one is looking at a scheme where there is no contribution. For example, a bare promise or something similar. And then B is important. In accordance with generally accepted accounting practice, they are shown in the employer's accounts. Now, this question of general accounting principles was the subject matter of expert evidence in this particular appeal. And the experts agreed. And I think I can take the tribunal to the passage in question. If we go to the core bundle, and if I take the court to page 101, paragraph 22. And perhaps I could ask the court to read paragraphs 22 and 23.
Yes.
So what the experts agreed was that because this, I'm so sorry, what the experts agreed is that where you create a pension obligation without any actual contribution, the appropriate deduction is, perhaps somewhat remarkably, the actuarial value of the liability incurred. And of course, that could be a very substantial sum, because what you're looking at is the total actuarial liability of paying the pension. it does seem rather, if I say so, rather odd that that should be the result of applying accounting principles. I think it was the late Lord Justice Harman who described accountants as the witch doctors of the modern world, and it is a very peculiar result. But, and here is the important point, if the actuarial value of the liability created is the correct deduction according to accounting principles, then that is it. That is how, following section 46, the accounts have to be made up. And the
When you say how the accounts have to be made up,
I'm so sorry.
you say how the accounts have to be made up. I mean, accounting rules govern how the accounts have to be made up.
Yes.
And section 246 says you can't have a deduction unless the accounting rules provide that for that.
Yes. Now,
But it doesn't go any further than that.
oh yes, this is where it becomes quite complicated.
I think you, with respect, you may have been referring to section 46 of the Corporation Tax Act. When you said section 46, I'm not sure you meant section
Oh no,
246.
I'm intended to refer to section 46.
Oh, sorry.
Yes.
Because no, let me just explain it. At the time these transactions took place, 2011, 12, 13, the Corporation Tax Act was in place because it was passed in 2009.
Yes, I see.
And what it provided was you compute profits in the first instance
Yes.
according to accounting principles. Then you have to ask, is there anything in the legislation which says, well, you can't do that?
Yes.
Now, the interesting question is that 246 is looking at non-contributory pensions, where under accounting principles, you would get a deduction for the liability created. Now, what it then goes on to do is interesting because it says in subsection 2, unless the benefits are ones in respect to which a person is on receipt chargeable to income tax, the expenses are not deductible. I mean, complete denial of deduction. But a pension, of course, if one simply promises to pay a pension to an employee, the pension will be taxable when received by the employee. I don't think it's necessary to take the court to the provisions of ITEPA, which provide that, but it's section 469, 470 and 471. So these, in this case, the benefits can be deducted. Subsection 2 doesn't stop it. But then we have to go to subsection 3, which then limits the timing of the deduction. Where the benefits are ones in respect to which a person is on receipt chargeable to income tax, if the expenses are to be allowed to be deducted in computing the amount of the profits of the employer under, for example, the Corporation Tax Act 2009, they are deductible in computing the amount of profits for the period of account in which they are paid. So section 246 is starting to do exactly the same job as 245 and section 1290, saying you can have a deduction, but only when you pay the pension. Now, the court may well ask, well, if that's the case, what on earth are these companies doing, claiming a deduction for the pensions that they created? The answer to the mystery is in subsection 4. In this section, Employer Finance Retirement Benefit Scheme has the same meaning as, and it refers to section 393A of ITEPA. And it's necessary to go back to section 393A to see how the mystery unwinds. Because section 393A is on page 28 of the authorities. And the court will see in this chapter, employer finance retirement benefit scheme means a scheme for the provision of benefits consisting of or including relevant benefits to or in respect of employees or former employees of an employer. I needn't read the other subsections. So the curious reader will then say, well, have we or have we not got an employer finance retirement benefit scheme here? And the answer is found in section 393B, which is on page 31. And the way section 393B works is that relevant benefits are defined very broadly, any lump sum, gratuity or other benefit provided, I need to go beyond A, on or in anticipation of retirement of an employee or former employee. Then we come to subsection 2, but benefits charged to tax under part 9. Pausing there, those are the same sections that I referred to earlier, sections 469, 70 and 71, whatever, or that would be charged, you can omit that, are not, going over the page, are not relevant benefits. So the position which emerges is this. If you have a non-contributory scheme and all it provides for are taxable pensions, it isn't a relevant, an employer finance retirement benefit scheme. And so the restriction on deductibility, which section 246 would otherwise impose, does not apply.
So, okay, in summary then, section 246 does not apply in this case.
Correct.
Nevertheless, as I understand it, you rely on it to indicate that the legislature is drawing a distinction between contributory and non-contributory schemes.
Yes. I think I'm entitled to say the legislation makes that distinction. But having made that distinction, can I put it this way, it grants a special privilege to schemes which only confer a right to a taxable pension because they are not relevant benefits.
So, as I understand it, these submissions might bear on the construction of section 1290.
Well, twofold, my lord. They bear certainly on section 1290. I mean, in my respectful submission, they show that the tribunal, the first tier and upper tier tribunal, have arrived at entirely the correct conclusion so far. But it's reinforced if one looks at the origin of the sections. That's one point. But the second point I make is this. What we find in the cases, Scots Atlantic, Hoey, and Marlborough, are references time and time again to a natural expected result of expenditure. And what we find are statements saying, well, if you pay wages, the natural expectation is that there will be a deduction. What we submit is that having gone through this miasma of sections. It's perfectly proper for the companies here to say, under ordinary accounting rules, we would expect to get a deduction, because that's what the rules say. And secondly, nothing in section 246 takes that right away.
But does any of this detract from the wholly and exclusively requirement?
Yes, it affects it directly, because when we come to wholly and exclusively, the authorities over and over again say you've got to distinguish the object from the effect. Now, in the case of salaries and wages, and we would say pensions, if the legislation gives you a right to deductions, then that is the natural and expected result.
Well, two things. First of all, the legislation doesn't say natural and expected, it says wholly and exclusively. But secondly, section 246 doesn't give you a right to deduct, it imposes a restriction on deduction. And the mere fact that the restriction doesn't apply doesn't give you a right.
No, it wouldn't give one a right. But on the other hand, you start from the position that you look at the accountant's rules and see what the result of applying those rules is. And I mean, that result, how can I put it, is not, so to speak, a voluntary result which you can accept if you like. It's mandatory. I mean, that's how you've got to do your accounts. So we start from the position that you show the deduction in your accounts because the accountants say so. And section 246 doesn't take away the right to the deduction. So the position you arrive at is that if you create unfunded pension rights, the natural consequence is that you get a deduction if, now, not necessarily, but in the absence, for example, of any artificiality, and if it's reasonably clear that the pension provision is reasonable in amount and that there is a need for pensions in the business. If you
and I dare say normally you would then satisfy the wholly and exclusively requirement, but here the tribunal said you didn't.
Well, my lord, I think the short answer to that is why not? If you have a company which hasn't paid any pensions in the past, and it suddenly wakes up to the fact that its senior employees don't have pension rights, it could well be in the interests of the trade that they should have pension rights. And those pension rights might well be reasonable in amount. And if that were the case, in my respectful submission, the natural starting point would be that the natural result is that you would get a deduction. It's not something you have to have a purpose of achieving. It just follows from the legislation.
Well, can I just go back to the first tier for a moment? They say on the facts that the provision of pensions was at best only an incidental aim, and that the primary purpose was to reduce the liability to tax. Now, those you can't get behind, can you, those findings?
Well, what I can say is that they have asked the wrong question.
Well, you can't forget about whether it's the right question. I mean, if it's the wrong question, then these findings are irrelevant. But you can't, can you challenge those findings that on the facts, the primary purpose was to reduce the liability to tax and the provision of pensions was only an incidental aim?
Yes, my answer is I can challenge them because in the binding authorities, the critical question is to distinguish object and effect. And properly understood, the deduction that these companies are claiming is actually simply an effect.
And that you can come to the law, but in terms of the facts we have to work from, those are the facts. That the provision of pensions was only an incidental aim, subjectively, and subjectively, their primary purpose was to reduce the liability to tax. Those are the facts.
That's what the tribunal found. Yes.
And you can't go behind those facts.
But I can say,
You can say it's the wrong question, but
yes, well, I do.
if it's a
That's
relevant
precisely
question,
what I do.
those are the facts.
That's what they said. But of course, if they misunderstood the test of how you distinguish between purpose and effect, then the conclusion may well be wrong. I mean, for example, if one goes to the upper tier tribunal decision, and if one goes to their conclusion on deducted wholly and exclusively, if I could take you to page 76 of the core bundle. At paragraph 48, there's a statement of principle from Scott's Atlantic. Then that's followed by paragraph 49. And the crucial sentence is second, I think the second sentence. However, in this case, the facts found by the first tier tribunal supported a conclusion that this was not a normal case, but a variation of the example referred to at 171 of Hoey of a payment being made with the object of artificially reducing the employer's taxable profit. Artificiality is emphasized in Hoey, and if one goes to Scott's Atlantic, the whole thrust of the decision was that there was artificiality in securing the deduction. To that we say, how can you say there's artificiality here? What is the artificiality? There's no artificiality at all. All that's happened is that the companies have promised employees pensions. That's all. The accounting treatment shows that as an expense. So where is the artificiality? The only artificiality, one would say, is in the rules of accounting practice. It's not in anything that was done by the trading companies here.
I don't think the first tier expresses itself in terms of artificiality, does it?
No, they didn't. It was quite interesting. It was the upper tier who were more prominent when it came to artificiality.
Would you agree that the main task of this court is to focus on whether there was an error by the first tier tribunal?
Essentially, yes, I would accept that, because it's their findings which are determinative, not the findings or anything said by the upper tier. But I will take, what I've done really, I suspect, is finished part one. I've shown the court the legislation and shown how a deduction can legitimately arise. We come then to part two, which is what is the appropriate test of deductibility? And of course, what is said against me, and it's very simple, is, well, the question is, these companies have a purpose of achieving a tax deduction. And the principles are set out properly in Scots Atlantic and in the Hoey and elsewhere. It's a question of fact, what was the purpose, and a question of fact, what is the effect. And so there is a decision on those facts, and that's it, it's unassailable. But I'm entitled to submit in my submission that is rather a simplistic, it's a simplistic approach. Why do I say that? Well, first of all, take the Marlborough case, if I may. Now, this has been supplied in a new form, and I hope I've got the right paragraphs. I've been trying to transfer my references. But the...
You say supplied. I don't think we've had those copies handed up to us yet.
Oh,
I assume they're in
I'm so
court.
sorry, I thought you had. Have you got them? Sorry? I can't hear. Where are they sent in? You got them?
Not on my person.
But
I can
where-
see a
have
pile
they
of
been-
authorities there. Does that include what we want?
Well, if you've got them, I think it'd be helpful to hand them in. Have you got them?
That's not Marlborough.
Have you got more?
No, not on my
Oh, my instructing solicitor, I think, believes that they did send in copies of the decision that you wanted.
I
I'm
think
not
we
sure where
received
you
them
got-
electronically, but we were told that we would get them in hard copy,
Oh, right.
which is the normal
Well,
practice.
yes. Can I just take some instructions as to how quickly we can get them?
I mean, I think if they're not in court, we better work by what we've got.
But
which
have we
is,
got it? Have we got Marlborough in the Court of Appeal?
It is.
Oh, it is.
Tab,
Okay,
tab 52. The-
Sorry? I'm told that the hard copies were posted, so I'm afraid I assumed all had them. But obviously they weren't.
I can't remember when we asked for them. Was it on Monday we asked for them? I can't remember, but they certainly were emailed. But I'm afraid I took it from what I had been told that we would get hard copies, and posting, if they were posted on Monday, would not guarantee delivery in time for us to see them today.
Well, we've only got one hard copy.
No, well, in that case, we better work by the transcript, which is at tab 52.
Marlborough in the original authorities bundle, I hope I'm right, comes at page 461 in the Upper Tribunal.
Yes, the Upper Tribunal.
It concerned a scheme where there was clearly a purpose of obtaining a deduction. That, I think, is clear if one goes to paragraph 2 on page 463. Marlborough entered into a tax avoidance scheme under which it made payments through certain trust arrangements which were then paid to Dr. Thomas by way of loans. Essentially, the objective of the scheme was that Marlborough would obtain a corporation tax deduction for the payments it made, and Dr. Thomas would not pay income tax on the amounts he received by way of loans. And in the paragraph 169, the tribunal recalled their view in respect of Mr. Woodman's view. Mr. Woodman's view differed from that of Judge Morgan. We have no doubt, they say, that Mr. Woodman's view that the contributions were non-deductible was correct. On Dr. Thomas's own evidence, the contributions were made in such amounts as were necessary to reduce the taxable profits of Marlborough to nil. The twin objectives of the Baxendale-Walker scheme, adopted by Marlborough and pursued by Dr. Thomas, were to empty Marlborough of profit and to advance that profit via the remuneration trust to Dr. Thomas by way of non-taxable loans. There was no intention of purpose to benefit the trade of Marlborough. And that's taken up at the end of paragraph 171. We agree with Mr. Woodman that the purpose of Marlborough in making these payments was to achieve a tax avoidance purpose for the benefit of Dr. Thomas and Marlborough, and was an end in itself. And then passing on to this court, the decision starts at page 503. And in essence, I think we find the decision at paragraph 120 and 126. Lord Justice Singh says at page 120, for my part, I am content to apply the principles as set out by Lord Justice Medici and Vodafone. Even on that basis, I would hold that the upper tier tribe in the present case was correct to conclude that the purpose in this case was not for the purposes of Marlborough's trade, but rather for the benefit of Dr. Thomas. It was a tax avoidance purpose. Of course, we have to bear in mind that Judge Morgan in this case had decided that the payments to Dr. Thomas were deductible. And later, paragraph 126, after a reference, incidentally, to A D Bly at 124. In paragraph 126, Lord Justice Singh was dealing with Mr. Blade's points in 125, that it was all a question of fact, and that the tribunal had decided that the payments to Dr. Thomas were deductible, and that was it. He then says, in my judgment, that decision does not assist to resolve the issues in the present appeal. The passage I have quoted was directed against an attempt to challenge a finding of fact on the ground that the evidence doesn't reasonably support that finding. The present case concerns a different issue, similar to the one which has arisen in a number of earlier cases, including cases which have reached the highest court, which is where the findings of fact are not disputed, but the assessment to be reached on the basis of these findings of fact by reference to the wholly and exclusively test is challenged. So, just because there is a finding, as there is in this case, that there was a purpose of securing a deduction, doesn't necessarily mean, when you look at the facts in the round, that the wholly and exclusively test is failed. which then brings me to the question. Well, what is the question which the tribunal has to answer in a case like this? And did they ask the right question?
Okay, can I just ask in that connection, if you go to paragraph 80 of the first tier, they say the parties agreed the test by reference to a passage from Scott's Atlantic.
Yes.
So do you accept that?
Yes, the statement of the test is correct.
Yeah.
You've got to distinguish purpose and effect. But then I ask, how do you do that in a case where the issue is deductibility of pensions?
Is it a case of how you do it where the question is deductibility of pensions? Or is your point more about how you assess whether a tax purpose, as opposed to other purposes, may infect a trade purpose?
I think both, my lady. I think that I'm entitled to say that there could well be a trade purpose in paying pensions to your staff, especially if you've got no pension in existence at all, which was the case with the second appellant. And if a question arose in that sort of situation, what you would expect to find is some discussion of whether the pensions were required, was there a need for them in the trade, and was the provision reasonable? Now, that's one side of the coin. And my criticism of the first tier tribunal in that respect is that they never answered these questions at all. What they did was concentrated on preliminary issues. They were, so to speak, stuck on the starting line and never looked at the finishing line.
I think that may be a criticism that they didn't make sufficient findings of fact.
Yes, but how do we know what they should? We don't know what they would have been. I mean, for example, we don't even know what the amount of the pensions was. They were actually being paid, apparently. That was found as a fact. In the case of D Bly, either three, it's differing answers to different parts of the case, either 3 or 4 of the pensions were actually being paid. And nowhere do we get any inkling of what the amount was.
I understand that, but what I'm trying to understand is what's before this court. Because I've just understood you to make a criticism of a failure to find facts by
Yes.
the FTT.
Yes.
But I don't read that in the grounds of appeal.
I think the way we put it largely in the grounds of appeal is that in a case where a trader institutes unfunded pensions, the natural and expected consequence, if the payments are reasonable in amount, is that they would be deductible. And if that is the case, that is an example, really, of effect and not purpose. But what I have to say in parenthesis is that it is the case that if the payments were not reasonable in amount, or if the trade didn't require them to be provided, the pensions to be provided, one would have expected a finding to that effect to be in the first tier tribunal's decision, but there's no finding at all. So we're left up in the air. The most helpful authority in my submission is the statement in Hoey, in the Court of Appeal. If I could just take the tribunal to that decision. Now this, I'm not sure, this time again, it will be in the page 395, I think, because the court hasn't got the hard copy. And at paragraph 171 on 447, there is, after a summary of all the relevant principles, largely derived from Vodafone, a very helpful short passage. It follows from the application of these principles that where a trader pays remuneration to an employee for services performed in furtherance of the business, it is not invariably the case that the payment will satisfy the wholly and exclusively rule. For example, the wages may be deliberately inflated so as to confer a personal benefit on the employee, or with the object of artificially reducing the employer's taxable profit. Graphic example is provided by Copeland and Clark. Adapting that to pensions, what I would submit to this court is that if a trader institutes unfunded pension arrangements, if those arrangements conferred reasonable pension provisions and were needed in the trade, for example, directors couldn't retire because they didn't have any pensions, and if there was no artificiality, you would expect there to be a deduction once you had gone through general accounting principles and once you had looked at section 246. And if that were the case, what I think the court was saying in Hoey was that a deduction would be the expected result, unless there were some other exceptional circumstances. If something is the expected result, then on the principles set out in Vodafone, it's an effect and not a purpose. Now, this court may say to me, but Mr. Thornhill, the trouble is, there isn't any finding in the first tier decision as to whether these pensions were reasonably necessary for the trade or that they were reasonable in amount. There's just nothing there at all. Instead, they've concentrated on lots of side issues, like there was no pensions advice and so forth, but those are not conclusive. Still, you can ask the question, were these reasonable pensions or were they not?
So I'm clear. In this context, your subjective purpose doesn't matter.
Yes.
If you are doing something which objectively would be reasonable,
Yes.
that is determinative.
Yes. and absent artificiality, but I've dealt with that. I think the court can appreciate there wasn't really anything artificial here in the same way as there was in Scott's Atlantic.
How does that fit, though, with the authorities of this court and the House of Lords that require you to look at subjective purpose?
Yes.
Authorities which are summarised in the passage in Scott's Atlantic.
Yes, yes.
Because my lord just put a question to you, which effectively you agreed with, that it was an objective test.
Yes, and if the test is objective, what one would say in these particular cases is the purpose was to create pensions in favour of certain individuals, which had the effect of securing a deduction. That's the proper analysis. And the first tier tribunal got it wrong.
And when you say they got it wrong, you say their findings are irrelevant. The fact that subjectively these individuals were not concerned to create pensions for the purposes of the trade, except as an incidental effect, but rather to obtain the tax advantage is irrelevant, you say?
Yes, because properly understood, however they might have concentrated their minds on deductibility and had it in mind, we want there to be a deduction. That is the natural consequence and therefore the effect of creating the pension liabilities.
Is that submission solid, having regard to what the first tier tribunal said at 96, 97 and 98 in relation to the uncommerciality of the arrangement?
Well, the interesting thing about the uncommerciality, perhaps I could just turn to those paragraphs.
Yes.
Because there are detailed points there. Yes, in those paragraphs, what we see, I think, are several things. The first, and this is more paragraph 96, is that whatever the initial advice was that they got, they exceeded that amount. Now, what we don't know, because no one said it, is why they exceeded the amount. I mean, it may be that the pensions under the original recommendation were not large enough.
But Mr. Thornhill, the burden of it was up to the taxpayer to produce evidence to prove its case in the FTT. And are you not stuck with the level of evidence that was produced and the FTT's appraisal of that evidence, which included making some adverse comments about witnesses and witness statements? On the particular point about that you've just mentioned about the numbers being higher,
Yes.
my recollection of the FTT is they effectively said that was unexplained.
Yes, there's no finding of it, there's no explanation of why.
Right, but then it's not really open to us now to start speculating, is it?
No, I think what I would say, my lady, is this. The case that the companies had to answer was this purpose argument. And in the midst of answering that, no one seems to have asked the question, well, were these pensions reasonable in amount? It seemed to be left up in the air. Similarly, the uncommerciality, the point that my Lord Justice Cobb mentioned in paragraph 98. They say that there was uncommerciality because no annuity providing benefits of the type was currently available on the market. But the fact is, though, that these pensions were paid, and how that came about, I just don't know. We don't know.
Well, how can the fact that they were paid be relevant?
Well,
I mean, that's something that happens years later.
Well, yes,
if we're
but
concerned with
someone must have been able to work out what the amount was, despite the fact that apparently there was no annuity on the market. In substance, what we would submit is that the right questions weren't asked. The right findings, which would have enabled any court to conclude at once that either these were deductible expenses or were not, are not made, because everything was concentrated on the question of purpose, but wrongly concentrated, because if the payments were reasonable in amount, and if there was a need for them in the course of the trade, there wasn't any artificiality. The normal expected result would be deductibility. It's just an effect. So having gone wrong on that point, what the tribunal should have done, would have been far more helpful if they had done it, was made some findings as to quantum and need, but none of that.
So can I just get back then to the summary of the law which was agreed for the FTT? That's paragraph 80 of the FTT.
Yes.
So these are the agreed principles that the FTT was applying. And where do your submissions fit into that summary of the law?
I'm so sorry, I didn't hear your Lordship's question.
These are the principles which
Yes.
the FTT was instructed by the parties to apply. So where does your submission fit into this summary of the law?
My submission fits in this way. The principles set out in paragraph 80 are perfectly correct. It's the application of them that where things have gone wrong.
So which bit should they have been applying that they didn't?
Well, it's look at paragraph 80 and 51. The object of the expenditure must be distinguished from its effect. Now that's very important.
Absolutely, but we see what object is means by going back to 50. The object has to be found by looking into the taxpayer's mind. So that's looking at subjectively
Yes.
what they are trying to achieve, and the FTT asks that question.
The FTT asks the question, and the proper answer to that question should have been the object was to create pensions which were going to be deductible because it was in the nature of expenditure on pensions to be deductible.
But the FTT didn't decide that because they decided that that wasn't the aim subjectively. Now you say that doesn't matter because you look at it objectively. So where do you find in this summary of the law something saying that you shouldn't look at what was subjectively intended, but what was objectively the case?
It's certainly the case that you've got to look into the taxpayer's mind. But when you look into the taxpayer's mind in this particular case, what you find is a decision that we need to institute unfunded pensions, which we are told and believe will be deductible.
Well, where do you find in the, I mean, on the face of it, the FTT is saying the opposite. So can you find something in the FTT that could be consistent with the individuals having thought subjectively that there was a need and acting for that reason?
I think my answer would be, yes, you do have to look into the taxpayer's mind. But if you look at what was in the taxpayer's mind, the only way they were going to get a deduction was to institute the pensions. And if one asks, was their object to institute pensions? The answer in my submission must be yes, and they went on and paid them. And if they hadn't instituted the pensions, you wouldn't get a deduction. Deduction follows entirely from assuming the obligation to pay the pensions. And then what follows is a choice to institute pensions in this particular way. But that's all right, because paragraph 55 in that same extract in paragraph 80 says you can do it in the most tax effective way, and that's all right.
Yeah.
I mean, in a sense, what the first tier tribunal was saying is, well, you wanted to have a deduction, and that was your purpose, but you couldn't get a deduction unless you incurred the expenditure. One follows from the other. And they paid the pensions, or so far they have. There's a very veiled hint in the upper tier decision that, well, they might not have paid the pensions at all, but I would say, as regards that, there's absolutely no evidence in the case of that. And in any event, I don't want to get too technical, but if you get a deduction for creating pensions and subsequently you don't pay them, the deduction is written back. For obvious reasons, you can't get away with something like that. So the way I put it to this court is that the object has to be the creation of the pensions, in the hope and expectation, perfectly reasonable, that there would be a deduction. And that's the fundamental flaw in the first tier decision. Of course, this court may say, well, it's all very well, Mr. Thornton, but I mean, how do we know that these payments were reasonable and required in the trade? And the answer may be, well, we don't know for certain. And it may be said, well, why didn't you produce evidence to that effect before the tribunal? To which the answer I can only give is because the taxpayer companies were meeting the case against them. No one was saying these payments were unreasonable in amount. It was all an argument about purpose. Everything that was found by the first tier tribunal all has a bearing on tax benefits and tax purposes.
But you're now telling us that that is indeed the answer to the case.
Well, the answer is here is expenditure on pensions. The natural effect of that expenditure would be to produce a deduction if certain facts were established. No one has established those facts in the first tier tribunal. And the only fair course in that state of affairs is to remit the matter to a differently constituted tribunal and sort the matter out by asking the right questions. There's precedent for that long ago in Copeman and Flood. And that would be the right answer here. But the remission would be justified on the basis that the identification of purpose by the first tier tribunal was in fact misconceived. You can't get a deduction unless you institute pensions. So the object was to institute pensions, albeit in a tax efficient way. But that's all right, according to Scott's Atlantic, in the passages to which my Lord Justice Newey directed me just now. So that is part two of my observations, subject to one point. And this is a tricky point because what I don't want to do is take the court into a case called Kilmorey-Aldridge at enormous length and, so to speak, go on an outing and then be told at the end, well, it isn't really very helpful. So may I just say this, hopefully not emptying the point of all substance. In Kilmorey-Aldridge, there was a very artificial tax scheme. And essentially, a building agreement was subjected over 6 days to a lot of artificial steps and bought back at a much higher price by a company called Kilmorey. In the Court of Appeal, it's reasonably clear, my submission, that Lord Justice Roskill, in dealing with Kilmorey, was only denying the uplift in price over and above the original value of some £2,500. And similarly, Lord Justice Stamp.
Yes, I don't think we've got the Court of Appeal decision.
No, well, now look, can I perhaps direct the court to the relevant passages? Or perhaps
Well,
write
obviously,
in later with the passages.
if you've got the references, maybe you could provide them, but again, we weren't provided with that Court of Appeal.
I have to apologise that happened, but there it is. I'm awfully sorry. The passage in Lord Justice Roskill is at 56G.
Of which report? Tax cases?
That's tax cases, yes. It's the case is reported in 50 tax cases, page 1.
So it's at page 56G.
56G
volume 50 of tax
is Lord
cases.
Justice Roskill saying it's the uplift, not the original value,
Thank you.
which is non-deductible. And Lord Justice Stamp at 64B agrees with him. And then in the House of Lords, it's Lord Reed on pages 82 and 83. I miss out Lord Morrison, it's not clear what he was saying.
Sorry, no, we do have the House of Lords decision, but we've got it in Simon's tax cases.
Yes, well, perhaps I could take your lordship to that.
Yeah.
I'm told if this, we have got hard copies, why it should be in this, just for Ransom and Hicks, I don't know, but we have got hard copies, so could I perhaps hand
Yes,
them up?
certainly.
Yeah, I was looking at Lord Justice Ross, and if I can just return there, he begins with.
And actually, just along the way, this hard copy includes the Court of Appeal.
Yes, it would do, yes, because the tax cases put them all together.
Yes, I see. So we could just identify the passages you were referring to.
So page 53, G, Lord Justice Roskell begins to consider deductibility. And really the key answer, the key passage is page 56G. Applying that test to the present case, that in my judgment is precisely what the Crown on the facts found is able to show. Here is a part of the expenditure sought to be deducted that can clearly be isolated. So he was saying, yes, well, if you can get the deduction for buying the land back at its proper market value, but not for the uplift. And Lord Justice Stamp at page 64B, just below B and C, between B and C, says the revenue cannot, so it is urged, dissect the payments made under a single agreement. This submission, if well founded, would, as I see it, lead to absurdities. So he was saying you can dissect, contrary to what the taxpayer was saying. And then Lord Justice Russell doesn't really add much on the point. The case then goes to the House of Lords, and Lord Reed at pages 82 and 83, the key passage really is, I think, the final paragraph on page 82. But what happens if, even without the non-trading purpose, the trader would have spent part of the sum for the purposes of his trade? Could I perhaps just ask the court to read that?
Yes.
So ultimately, Lord Reed didn't decide the point, but I think he made his views fairly clear. Lord Wilberforce, at page 93, just below the letter C, my lords, I so entirely agree with the reasoning as to this matter of Lord Justice Roscoe that I can deal with this matter shortly. Anything more would repeat his reasoning, on which I cannot improve. So he was agreeing with Lord Justice Roscoe, who apparently was deciding that it was the uplift, not the whole price, that would not be deducted. Then Lord Simon, simply at the top of page 98, agrees with the Court of Appeal. Then finally comes Lord Cross, and he agrees that the deduction failed as regarding the uplift, but he does at the page 100C offer some general observations. Could I ask the court to read from C down to F?
Yeah.
Which page you
C down to F.
want? Page.
And this is page
100.
100.
Yes, I'm afraid.
It comes up as a
one
double O
has
on
Yes.
the.
not sure what's happened to it.
Is the 19240 the uplift? I assume it is.
I'm so sorry, my lady.
Is the £19,240 referred to at letter E the
Yes.
uplift?
That's the part of the extra 77,000 that was paid in the first year. But it's part of the uplift.
Part of the uplift.
Yes.
Okay.
Now it's speculated, it is only speculation, in one of the tax authorities, Whiteman and Sherry on income tax, that it was these observations in Kilmorey that may have led to section 54(2) of the Corporation Tax Act 2009. Now, I'm not sure, in your authorities bundle, do you have a page 539?
Yes.
And if you turn to 539 and 540, if I just ask the court to read it, you can see that the suggestion is made is these observations in Kilmorey that may have led to the enactment of section 54(2) of the Corporation Tax Act 2009.
Sorry, where are you reading from?
I'm reading from bottom of page 539.
Yeah.
Down really to the top of the first paragraph in 541.
Yes.
Then if the court could turn to page 77 of the authorities bundle with their find section 54.2. If an expense is incurred for more than one purpose, this section does not prohibit a deduction for any identifiable part or identifiable proportion of the expense which is incurred wholly and exclusively for the purposes of the trade. And that provision would, in my submission, have supported the course of action which Lord Reed was advocating and Lord Cross, and all their lordships other than perhaps Lord Morris. Of course, it will be said that section 54.2 doesn't help in lots of cases. For example, take a case such as Mallew and Drummond. Deductibility for barristers' clothing in court. Clearly, you couldn't segregate the expenditure in a case such as that. But if, as in Kilmorey, there was a proper price to pay for the building agreement, that could be deducted because, in my submission, the purpose of obtaining a tax advantage disappears once you strip away the increment. And that is very clear in my submission if one goes to Lord Cross, because Lord Cross is not saying that benefiting the relative is not a purpose. Quite the contrary. If one goes back to page 100, he says on page 100 of the letter D, one of the purposes for which the retailer is entering into the transactions with his son-in-law is to help him in his business. So it's not saying it's an incidental result, it's a purpose. But if all he does is to buy the goods at the right price, the natural and expected consequence is, if he wanted a deduction, that he would get it. In other words, if I can put it this way, if in the course of a trade, the person pays a sum of money, which is the correct price to pay, even if there was some other purpose, it falls away. If you like, it becomes an effect and not an object. And so in the present case, if, which I concede there's no actual finding about, if the pension provision was reasonable, it certainly wasn't artificial, and had a purpose to serve in the trade, which is almost self-evident because the pensions were paid. The fact that a tax advantage was sought properly reduces to being an effect and not a purpose. And the fundamental flaw in the first tier tribunal's decision is that they approached the matter very simplistically. Oh yes, they wanted to get the deduction, so that was the object. And getting the pensions was an incidental effect. But when you think about it, that is a very perverse analysis, because you couldn't get the deduction unless you paid the pensions. The real object was the pensions, which brought with it the benefit of a tax deduction. I've dealt with artificiality. I think I can say no more than there's nothing artificial here remotely similar to the complicated Baxendale Walker scheme in Marlborough, or to the deliberate attempt to circumvent Schedule 24 in Scots Atlantic. But given that the first tier tribunal didn't make any finding on reasonable amount, perhaps the fair course is for the matter to be remitted to another tribunal to have that matter properly determined. That, I think, concludes part 2, and it only leaves part 3, which I can deal with extremely briefly. What we submit is that if Scots Atlantic stands for some weaker principle, that obtaining a tax objective immediately prevents deductibility, that's far too wide. The case, properly understood, was a case of extreme artificiality, where Mr. Drybrough was doing exactly what happened in Marlborough. How can I get all the money out of the company without paying tax? The elixir of life, which, needless to say, is very rarely obtained, and it certainly isn't trade purpose. So I don't think I have to concentrate very long on part 3. The critical issue is part 2.
Yeah.
It's probably sufficient to say so at this stage. So unless the court has any questions.
No, I don't detect any, so thank you very much, Mr. Thornhill. Ms. Murray.
My lords, my lordship, I plan to respond to the structure of my learned friend's skeleton and then deal with any points I haven't dealt with yet. I'll start with the key facts found by the FTT, if I may, because we somewhat skirted over those. So we know that the first appellant, D Bly, claimed deductions in its accounts in respect to the herbs for the accounting periods ended 30 November 12 and 30 November 2013. And the second one, CHR, for the accounting periods 31 March 13 and 31 March 14. In the case of each appellant, the deductions claimed in respect to the herbs were 80% or 100% of their profits for the accounting period, which would otherwise be chargeable to corporation tax. The herbs had been proposed to the appellants by Charterhouse Accountants Limited at a meeting with the appellants' directors and it had been disclosed to HMRC under the Disclosure of Tax Avoidance Scheme rules known as DOTAS in the Finance Act 2004. And that's para 6 of the FTT decision. Charterhouse promoted the herbs to other taxpayers who also appealed against the assessments made to the FTT. And the appeals were designated lead appeals. That's para 7 of the FTT decision. In relation to the first appellant, the FTT made certain key findings which are not challenged by the appellants. So they were not satisfied that there was a separate meeting of the directors to discuss remuneration.
This is for AD Bly, is it?
Yes, my lady. And similar findings were found for both appellants. This is for AD Bly, so that's para 26 to 27 of the FTT decision. So no separate meeting to discuss remuneration. The engagement letter issued by Charterhouse to the first appellant after that meeting contained certain key clauses. That's the FTT at 30 to 32. We're on page 102 of the bundle if you want to follow it in the bundle. So, warning regarding tax planning. 1.1. Any tax planning covered by this engagement letter may be considered to be aggressive tax planning by HMRC, and as such, they're very likely to raise inquiries into any transactions affected as part of the planning and may not accept the interpretation of any tax legislation that's been relied upon as part of the planning. 1.2. You should only proceed with such planning if you're prepared for such an inquiry and to pay any tax, national insurance and other duties that would be payable in the event that the planning failed to achieve its anticipated outcome. 2.1, we shall assist you in establishing an unfunded, unregistered retirement benefit scheme, an URBS. However, we cannot advise on the suitability of an URBS as a mechanism for providing pensions to employees. Council will be instructed to advise in respect to the tax consequences of the matters referred to in 2.1 above. You will be relying on the advice given by Council. 2.6, we shall recommend and liaise with a remuneration consultant with a view to them producing an estimate of the overall level of rewards for specified employees, including the provision that can be made for each employee who is to be rewarded by the company by way of an URBS. And then later that day, on the 22nd of November 2012, a company known as Synergis, Mr. McGill, was appointed to act. Their report was provided on the 27th of November and stated that they were appointed, and this is on page 103 of the bundle, if you're following it, it's FTT 37, as remuneration consultant to the first appellant for the specific task of giving an opinion as to the level of pension provision that could be made in this current financial year ended 30 November 2012 for various directors. And then FTT 38 finds that Synergis agreed that the pension provision for the year should be 1,040,000, which was equivalent to 100% of the first appellant's projected profits for the year, apportioned between the 6 directors in the percentages listed there. This is at FTT 33 to 38, so we're on page 102 to 3. So Mr. Bly 25%, Mr. McSkimming 25%, Mr. Arnold 12.5%, Mr. Thompson 12.5%, Mr. O'Connor 12.5%, Mr. Pring 12.5%. There was no reference in the report produced by Synergis to any opinion as to the overall level of rewards for the directors. So FTT 39 finds that the report was expressly restricted to what was termed the commercial suitability of the pension benefits, whatever that means, but we do know it wasn't to do with the level of rewards, and did not offer, quote, financial, pension, investment or tax planning advice, and that's FTT 39 still.
Sorry, when you say there's nothing to overall level of rewards, you're referring to para 37 there. The FTT doesn't decide what commercial suitability actually covered or meant.
No,
Did
this is
it? Or at least I felt I was left with a bit of
39. I'm on, not 37.
Yes, I know, but you just said whatever it covered, it didn't cover overall level of rewards, but I'm just trying to tie that point down.
I'm sorry, my lady, I'm being a bit dear. The was simply that it doesn't discuss the level of rewards.
Unless you think that's part of commercial suitability.
Well, it would have been, but it wasn't dealt with.
So, I mean, you presumably, you obviously saw this report. I can't remember whether we've got it in the supplemental or bundle or not. We probably haven't. But what is presumably being said is, in the case of Mr. X, it isn't said, well, his pay now is such and such, and pension would be such and such, and putting the two together, that might be an appropriate level of reward or whatever.
Precisely, my lord. Yeah. So there was no consideration at all. As to the level of pension or the overall level of rewards, or whether that would incentivise employees or whether it was commercial, nothing.
Do we have the report?
I don't think they are in
Okay.
bundles.
So you're saying, well, we can only take whatever the report said from what the FTT summarised it as.
But there is no challenge to that finding of fact. I mean, the appellants have those reports.
Where is the exact finding of fact on which you reply?
So this
Rely?
is FTT 39 on page 103.
Well, yes, that's the disclaimer, but where's the positive finding about what the report did say? Sorry, I'm probably just being slow.
I'm sure it's me, my lady. I haven't got it in front of me.
I think all we've got is 38.
Coupled, as you say, with 39. 37, I mean.
Yes, apologies, my lady, that is it. But it's implicit in that, in that there is no offering of financial pension investment advice, that they don't consider the level of pensions. They're expressly not advising on it.
That's 92, isn't it? In the FTT petition paragraph. Synergis did not offer financial pension or investment advice.
That's the FTT finding, yes.
Yeah.
Thank you. And then the day after the delivery of the Synergis report, 28th of November, the directors had a meeting to propose that 100% of the projected pre-tax profits, which were then 1.3 million, will be used to provide the ERBs with the relevant directors. The directors agreed to appoint Synergis as consultants at that meeting. And then at the end of paragraph 41, the FTT find that in fact Synergis had already provided their final report on the 27th of November, and no later report or explanation was provided to the FTT. And then at 42, the FTT finds that on the last day of the company's financial year, 30 November 12, the directors had a meeting at which it was agreed that 100% of the projected pre-tax profits, 1.3 million, would be used to provide the unfunded pension arrangements with the relevant directors. The rewards determined by the directors diverged in several respects from those recommended by Synergis. I believe this is a point you made earlier, my lady. That's a 42 to 43. So the apportionment between the directors was different to the report. And there was a difference in the amount of the profits to the estimate used in the report. The estimate had been 1,040,000. And then at FTT 44, the tribunal finds that on the same day, AD Bly's sole shareholder resolved to make a pension provision, and AD Bly entered into the ERBs. The findings in relation to the following year begin at 46 on page 104. So on 14th of November 2013, the first appellant resolved to enter into further ERBs for directors, with the pension provision being 80% of that year's projected profits of 3 million, The board appointed FLB to review the remuneration packages of the directors, including the proposed pension provisions. And then at 47, the FTT finds that FLB limited the scope of its advice by almost identical terms to Mr. McGill at Synergis. So the opinion is given based solely on the commercial suitability of the provision to be made and does not offer any opinion on the financial, pension, investment or tax planning advice. These matters are for the company's relevant advisors to deal with. And no such advice was taken by any of the appellants. And then FTT 48 finds that on 28th of November 13, the first appellant's directors resolved to enter into the 13 agreements. The minutes of that meeting refer to projected pre-tax profits of 2.9 million, but the final account showed a pension provision of 4,435,180, being 80% of the pre-tax profits of 5,543,975. And then at paragraph 49, there's a finding that the herbs agreements had been misplaced. And so on the 13th of May 2014, there was a meeting of directors to approve the signing of replacement agreements for those supposedly entered into on 30th of November 2012. Those appear to have been signed on the 17th of June 2014. And finally, at FTT 50, the finding that the first appellant subsequently paid pensions to 3 directors in accordance with the arrangements. The FTT then makes findings of fact on similar issues in relation to the second appellant, starting at 51 on page 105. At paragraph 55, the FTT state we don't accept that there was a separate board meeting to consider the remuneration packages of key individuals prior to Mr. Galpin's discussions with Mr. Atkinson about the establishment of the herbs. The warning in the engagement letter from Charterhouse is set out at paragraph 58 on page 106. And at paragraph 59, the part of the engagement letter which states we cannot advise on the suitability of an herbs as a mechanism for providing pensions to employees. And if required, we shall liaise with a remuneration consultant with a view to their producing an estimate of the overall level of rewards for specified employees, including the provision that can be made for each employee who is to be rewarded by the company by way of an herbs. And FTT 60 to 76 sets out similar findings in relation to the emails and board meetings. So we don't need to go through those. The terms of the herbs are then summarised by the FTT at paragraph 77. I don't think I need to read those out, do I?
No.
So in addition to the extensive documentary evidence considered by the FTT heard witness evidence from the directors of the appellants, Mrs. Skimming and Hellier for the first appellant and Mr. Galpin for the second appellant. But the FTT makes findings as to the relevance and credibility from paragraph 12 onwards. That's on page 98 of the bundle. So Mr. Hellier's evidence wasn't relevant. And as to the evidence of Mr. McSkimming and Mr. Galpin, the FTT found at paragraph 13, the witness statements of Mr. Galpin and Mr. McSkimming contained many passages that were identical or materially similar, save as to names, dates, and amounts. Ms. Murray put many examples of such passages to Mr. Galpin and Mr. McSkimming in cross-examination, but we need only quote 3 examples for purposes of illustration. And then paragraph 14 sets out the paragraph of Mr. Galpin's witness statement, which describes the role of the remuneration consultant to consider the current package for 2 individuals and to consider whether this was commensurate to their contribution to the firm, taking into account the appropriate level of remuneration, etc., and whether the proposed revision would provide an adequate pension to maintain lifestyle on retirement. And it goes on to state, it was considered by the remuneration consultant that current pension arrangements and the lifetime limit for approved pensions at this time of 1.5 million would be insufficient to ensure that the members would be able to maintain their current needs and lifestyle in retirement. and that a provision of a pension under an herbs agreement would resolve this and could reasonably form part of the key individual's remuneration package, whilst allowing the business to continue to operate and expand. We've seen that that is flatly contrary to the terms of engagement with the remuneration consultants, Synergis and FLB, which exclude those considerations. The same goes for the similar paragraph 9 in Mr. McSkimming's statement, set out in paragraph 15 of the decision. And then the following paragraphs compare two further paragraphs in their statements, which are almost identical, up to paragraph 19. So the FTT, far from what my learned friend has said, did not fail to turn its mind to these questions. It did turn its mind to relevant questions, and it rejected their evidence on them. So as a result of that, the FTT made its findings at paragraph 20. So the two sentences at the end of paragraph 20. So Mr. McSkimming said that Charterhouse didn't tell him what to write. We don't accept that as being literally true. The similarities between the two witness statements can only be explained by the fact that they shared a common source. Having read both of their statements and heard what the witnesses said about them in cross-examination, we conclude that to a large extent Charterhouse told both witnesses what to say and how to say it. The FTT expressly stated that they each maintained that the primary reason for the arrangements was to provide future pensions for individuals in a way that didn't involve a reduction in working capital, and rejected that evidence. So that's at paragraph 88, in stating that the weight to be given to their witness statements was considerably reduced in light of the issues it had identified. So the FTT found that the proposal to enter into the herbs was brought to the appellants as a tax planning scheme by Charterhouse.
Sorry, where are you taking that from?
Apologies, my lady, this is paragraph 91 on page 113. Both witnesses said the proposal put forward by Charterhouse was primarily a pension scheme, although tax was also discussed at the meeting. It seems to us to be unlikely, if not completely illogical, that the appellants would seek advice on remuneration and pensions from Charterhouse, which did not purport to advise on either of those things. Charterhouse's letters of engagement stated that it couldn't advise on the suitability of an herbs as a mechanism for providing pensions. In the letters, Charterhouse offered to liaise with a remuneration consultant who would produce an estimate of the overall level of remuneration, including the herbs for certain directors. In our view, if the appellants had genuinely been concerned about the level of remuneration and pensions provision which they made for the directors, they would have sought advice from an executive remuneration consultancy firm and a pensions advisor rather than a firm of accountants. We're not satisfied that the appellants sought advice about directors' remuneration from Charterhouse, which then suggested that they should set up an herbs. We find that the proposal to enter into the herbs was brought to the appellant as a tax planning scheme by Charterhouse. And then 92, in his witness statement, Mr. Galpin said that the herbs was first and foremost a pension scheme, although the directors were aware of the tax benefit. If that was true, then we cannot understand why the directors of CHR did not seek any pensions advice. At no point did either appellant take advice on the most appropriate way to provide pensions for the directors. Both appellants were advised by Charterhouse to instruct a remuneration consultant. The remuneration consultant specifically did not give pensions advice. In their reports, both Synergis and FLB stated that they didn't offer financial, pension or investment advice. And then at 93, if the appellants had wanted to incentivise, motivate and retain key employees, then we would have expected the appellants to seek advice on the competitiveness of their remuneration packages, but they did not do so. So having considered all the evidence, including that there was no separate meeting of the directors to consider pension remuneration, that's it, paragraphs 26, 7 and 55 of the FTT, the limited roles of Synergis and FLB, the absence of any advice to the companies regarding comparative remuneration levels, and the warning notice in the consultant engagement letters, the FTT stated at paragraph 94 on page 114. Charterhouse's engagement letters show that tax was at the forefront of the appellants' minds when they were considering establishing the herbs. And then at paragraph 95, we've concluded that the provision of pensions to directors was at best only an incidental aim of the appellants when they established an herbs and entered into the unfunded pension agreements. This is shown by the fact that the size of the pension provision was determined as a percentage of the profits before tax, regardless of the level of those profits and without discussion of or reference to any future pension benefit to the directors. The FTT also took into account the failure by the appellants, without discussion or explanation, to limit the relevant pension provisions as suggested by the consultants. So at 96, the FTT finds the appellants had a disregard for the actual amounts of the pension provision made in relation to the individuals. And then at 97, they find in 2014, the directors of CHR seem to disregard FLB's advice that the provision should be 80% of the estimated profits, and decided to allocate all of the profits for the year to the unfunded pension agreements. There was no discussion or explanation for the decision to make greater provision for pensions than that recommended by FLB. The FTT was also unconvinced by the commerciality of the arrangements and considered that in relation to the liabilities incurred by the appellants, the future business risk remains substantial. That's at 98. And then the FTT's conclusion at 99 was that on the basis of the facts found and for the reasons given, we've concluded that the appellant's primary purpose in entering into the unfunded pension agreements was to reduce their liability to pay tax without incurring any actual expenditure. It follows that the liability to pay pensions under the unfunded pension agreements was not incurred wholly and exclusively for the purposes of the appellant's trades. That brings me on to the law. So section 54, we don't need to go back to it. It's on page 77 of the bundle. Subsection 2 provides for an apportionment of expenditure where an identifiable proportion is incurred wholly and exclusively for the purposes of the trade. The appellants hadn't actually pleaded any contention in relation to subsection 2. I'm not sure if they are pleading it for the first time now. They haven't said that they are, but it certainly sounded from the submissions immediately before I stood up that they were trying to make a point in relation to subsection 2. It wasn't a submission that was made in the FTT. There wasn't any evidence to support that a proportion of the expenditure is incurred wholly and exclusively for the purposes of the trade. And there isn't any evidence before this court either to demonstrate that. So do with it what you will, but I would ask you to disregard that submission. It's not pleaded. With the report. If you'll forgive me for being slightly noddy and going over these, the principles derived from the case law were correctly summarised in Scott's Atlantic at 50 to 55. So Scott's Atlantic starts at 321 of the bundle, and paragraph 50 is redlined on page 334. The principle that the test is subjective is set out in paragraph 50. So the FTT needs to first, as the taxpayer's object in making the expenditure has to be found, it inevitably follows that, save in obvious cases which speak for themselves, the FTT needs to look into the taxpayer's mind at the moment when the expenditure is made. Page 198 is where Mallory and Drummond starts. So it's Lord Brightman in Mallory and Drummond at 669. So I'm sure you're familiar with this case. It's a famous case about whether a barrister's expenditure on her suits and shirts and black shoes was wholly and exclusively for the purposes of her profession. She contended that, but for the requirements of the profession, she would not have bought those clothes, and the preservation of warmth and decency didn't cross her mind when she bought them. So the majority of the House of Lords held it was necessary to ascertain the purposes of the business and therefore to discover the taxpayer's object in buying the clothes. Lord Brightman gave the lead judgment, which starts on page 200.
So sorry, we should be turning up Mallory and Drummond.
If you wouldn't mind.
Yep.
So it's next to D on page 202. So So the commissioners need to look into the taxpayer's mind at the moment when the expenditure is made. He then states that object must be distinguished from effect, and there's a well-cited example given there next to F of a doctor going to treat a friend in the south of France, and the object of the trip is to treat his friend, but in effect is that he stays with his friend in the south of France for a week. And then he states 2 lines down from F, the question of fact will be whether the journey was undertaken solely to serve the purposes of medical practice. This will be judged in the light of the taxpayer's object in making the journey. The question will be answered by considering whether the stay in the south of France was a reason, however subordinate, for undertaking the journey, or was not a reason, but only an effect. And then 52 of Scott's Atlantic in the Upper Tribunal states, based on this example, what the FTT must not do is to conclude that merely because there was an effect, that effect was an object. So it's well settled that the taxpayer's aims or objects or purposes, whatever you want to call them, have to be established, and unless they are wholly and exclusively for the purposes of the trade, Section 54 precludes a deduction. They also said that although her conscious motive was of vital significance in ascertaining her object, it wasn't decisive. One object of her buying the clothes was the provision of clothing she needed as a human being. So that's why the expenditure was disallowed. So the principles that object must be ascertained by inquiring into the subjective intentions of the taxpayer and must be distinguished from effect are cited in Vodafone and Shaw, which starts on page 237. There were 2 issues in that case, and it's the second one that we're concerned with. So I can ask you to read the head note at 2 on page 238. And that comes from the passage starting just below E on page 245. So the leading modern cases on the application of the exclusively test are Maloney and Drummond and McKinley and Arthur Young. From these cases, the following propositions may be derived. 1. The words for the purposes of the trade mean to serve the purposes of the trade. They don't mean for the purposes of the taxpayer, but for the purposes of the trade, which is a different concept. A fortiori, they do not mean for the benefit of the taxpayer. 2. To ascertain whether the payment was made for the purposes of the taxpayer's trade, it's necessary to discover his object in making the payment. Save in obvious cases which speak for themselves, this involves an inquiry into the taxpayer's subjective intentions at the time of the payment. The object of the taxpayer in making the payment must be distinguished from the effect of the payment. A payment may be made exclusively for the purpose of the trade, even though it also secures a private benefit. This will be the case if securing of the private benefit was not the object of the payment, but merely a consequential and incidental effect of the payment. 4. Although the taxpayer's subjective intentions are determinative, these are not limited to the conscious motives which were in his mind at the time of the payment. Some consequences are so inevitably and inextricably involved in the payment that unless merely incidental, they must be taken to be a purpose for which the payment was made. And then to these propositions, I would add one more. The question does not involve an inquiry of the taxpayer whether he consciously intended to obtain a trade or personal advantage by the payment. The primary inquiry is to ascertain what the particular object of the taxpayer in making the payment was. Once that's ascertained, its characterisation as a trade or private purpose is, in my opinion, a matter for the commissioners, not for the taxpayer. So those are very well established principles. In my submission, what my learned friend is asking you to do is to transpose the incidental effect of their intention of obtaining a corporation tax deduction, which was the incidental effect being the payment of the pensions, and make that the object. As a matter of fact, it wasn't the object. There's no Edwards and Bairstow challenge to that. case of McKinley is cited at 53 of Scots Atlantic, which starts at page 208 of the bundle. So it's a House of Lords case in which Lord Oliver gave the lead judgment in favour of the Crown in relation to an assessment on a partnership in relation to removal expenses incurred for its partners to encourage them to relocate around the country for the benefit of the partnership's business. So it's cited in Scots Atlantic for the proposition that thirdly, some results are so inevitably and inextricably involved in particular activities they cannot but said to be a purpose of the activity. And as a result, the conscious motive of the taxpayer is not decisive. It's of vital significance, but is not the only object which the fact-finding tribunal is entitled to find to exist. Another way of putting it is that the FTT must take a robust approach to ascertaining the purposes of the taxpayer. And that's in the final passage starting at H on page 215 of the bundle. The Upper Tribunal in Scots Atlantic then states at 54, there's one point to add. Neither the statutory provision nor any of the cases indicate that the way in which an expense is incurred will determine whether the expense is deductible. The question is, what is the object of the expense, not what was the object of the means of incurring it. That's not to say that the means by which the expenditure is made cannot be one of the circumstances to be taken into account in determining its purpose. The starting point in this case, as my learned friend appeared to concede, is that the appellants were trying to get a deduction for corporation tax purposes. He seemed to be saying that the pensions were an inevitable or natural consequence of that, but the object was the deduction. Like I say, it seemed to be that he admitted that. So, and then at 55, a trader may have a choice of the way in which it achieves an end, which is exclusively for the benefit of the trade. The choice may be influenced or indeed wholly determined by the tax consequences of each choice. The taxpayer is perfectly entitled to order its affairs in a way which incurs the least tax liability. The mere fact that a choice is influenced or dictated by the tax consequences doesn't necessarily mean that the choice involves a duality of purpose as regards the expense. The words of Millet LJ are just as relevant and applicable where there's a choice as where there is not. In each case, the question is whether the payment is made exclusively for the purposes of the trade, and that's a question of fact for the FTT. So all of those principles set out in Scots Atlantic are well established House of Lords and Court of Appeal principles. But it's important to note in relation to this that the appellants were not making a choice as to how to best remunerate their key individuals. There are no facts to support that they considered it at all, and the findings point away from that and towards the only consideration being to claim a deduction against the taxable profits. So it's a case where the payments made to key individuals are an incidental consequence to the aim of achieving a tax deduction of 100 or 80% of the profits. So the case of Hoey, apologies for my pronunciations incorrect, we've seen that at paragraph 170, which is on page 446 of the bundle, Lord Justice Henderson cites the passage of Vodafone and Shaw.
Sorry, we better just catch up with you. So we're
with paragraph
in
170.
50 and sorry, which page?
So page
Which
446,
paragraph?
I believe, and paragraph 170.
Yeah.
So that case is relying on the same principles. So Scots Atlantic didn't decide anything new. simply cited and applied these principles, and they were cited and applied by the tribunals in our case. So I need to say something about Edwards and Bairstow. So the Upper Tribunal in the present case at paragraph 35 on page 73 of the bundle mentions that the Edwards and Bairstow principles were more recently enunciated in Georgiou. It wasn't
Sorry. Paragraph 34.
Sorry, paragraph 35, I think it is.
Yeah.
So for a question of law to arise in the circumstances, the appellant must first identify the finding which is challenged, secondly show its significant relation to the conclusion, thirdly identify the evidence, if any, which was relevant to that finding, and fourthly show that that finding on the basis of that evidence was one which the tribunal was not entitled to make. What's not permitted, in my view, is a roving selection of evidence coupled with a general assertion that the tribunal's conclusion was against the weight of the evidence and therefore wrong. I'll come back to that in the context of replying to my learned friend's submissions, because it's not clear whether he is trying to make an Edwards and Bairstow challenge or not. He doesn't have permission to. So in terms of the approach to the law taken by the FTT, so the FTT identifies the principles at 50 to 55 of Scots Atlantic, and states that it was necessary to determine the object of the appellants. So that's at 80 to 81 of their decision. It's not applying the decision in Scots Atlantic, it's applying the principles that are set out. And it states halfway down paragraph 81, that means deciding whether reducing profits for tax purposes in a tax year by 80% or 100% without incurring any actual expenditure during the same period was the object or one of the objects of the appellants, or merely a consequential and incidental effect of entering into the unfunded pension agreements. It's asking exactly the right question in my submission. And that means determining the underlying purpose for the debit in the accounts. So there's no dispute between the parties as to the accounting treatment. As my learned friend said, there were two expert accountants. The FTT then proceeds to make the findings at 95 to 99, based on the evidence and the facts which the court has been through. At 95, we concluded that the provision of pensions to directors was at best only an incidental aim of the appellants when they established an IRBs and entered into the unfunded pension agreements. I've read that out to you already. So in my submission, the FTT applied the correct law and reached the correct conclusion. And as I say, there's no Edwards and Bairstow challenge to that conclusion. In terms of the decision of the Upper Tribunal, the grounds of appeal to the Upper Tribunal are summarised at paragraph 21 on page 69 of the bundle.
Sorry, page 69 of the court bundle. Or in the UT decision.
In the UT decision,
Yes, I see.
I believe it's page 69 of the bundle, paragraph 21. Ground 1 appears to rely on the appellants having chosen a tax efficient way of achieving a different purpose. So that's the same as paragraph 1.3 of their skeleton and the oral submission made today. Ground 1 of their Court of Appeal grounds relies on the FTT having confused object and effect, and distinguishes Scots Atlantic, in which the deduction was far from being a natural consequence. It was a means to an end. And I'll come on to submit that it's completely the wrong approach to compare the facts in Scots Atlantic at all. Ground 2 in the Upper Tribunal was that the FTT erred in finding that Scots Atlantic was authority for the proposition that the acquisition of a tax advantage can of itself constitute a secondary benefit, and that Scots Atlantic is incorrect. So the grounds for the Court of Appeal appear to make the same arguments, which were correctly rejected by the Upper Tribunal at paragraphs 26 to 44. So paragraph 28 states the principles.
Sorry, where are you reading from now?
Apologies, my lord. It's page 72, paragraph 28
Of the Upper Tribunal, sorry.
of the Upper Tribunal.
Oh, I see, yes. Yep.
So paragraph 28 states the principles summarised in the passages of Scots Atlantic are well established and based on high authority. Paragraph 29 states it would be fundamentally misconceived to compare the facts of Scots Atlantic, which the FTT didn't do. It applied the correct legal principles which it set out. And then at 30 to 31, they set out and reject Mr. Thornhill's proposition that the FTT erred in not finding an all-pervading object of reducing their corporation tax liability by whatever means possible. And then it gives 4 reasons for that, which were all correct in my submission. In the first place, the finding referred to at 67 of Scots Atlantic was actually a finding made by the FTT in that case, which was then the subject of some criticism by the Upper Tribunal in the paragraphs which followed, as having the potential to be an unwarranted gloss on the statutory language. Secondly, the FTT in this case would have erred in law in directing itself to determine whether there was an all-pervading purpose of reducing tax, whatever that phrase might mean, because that's not the inquiry required by the wording of section 54. Thirdly, in any event, the FTT found that the primary purpose of the appellants in entering into the arrangements was to reduce their liability to tax without incurring actual expenditure. And that's FTT 99. Fourthly, given the fact-sensitive nature of the inquiry, the FTT was right not to embark on a comparison of the facts of other cases. And then at 32, the Upper Tribunal states the FTT did not confuse object and effect. It was well aware of the distinction. And then at 33, the Upper Tribunal rejects Mr. Thornhill's contention that the FTT erred in taking into account irrelevant factors. At 34, on page 73, the Upper Tribunal there refers to the fact that the appellants were refused permission by the Upper Tribunal to argue that the FTT erred in an Edwards and Bairstow sense. But then they go on to decide that there's no such error of law by the FTT anyway. So at 36, they state that the factors mentioned are not irrelevant, and the appellants are seeking to do what the court in Edwards and Bairstow and Georgiou prohibit. The factors that are listed there in paragraph 33 of the Upper Tribunal decision are the same factors listed in the appeal skeleton at paragraph 3.15.
Are you just about to come to a slightly different point? If so, we might break.
I'm happy to break there anyway, Mum.
Let's leave it there for a moment. So 2 o'clock.
Court rise if able.